as I was going through the basement, I opened the door to the room and just knew immediately that I'd found her, because there was a white blanket and her eyes were closed. I feared the worst, but yet I'd found her. Even though there was this rush of, thank God I found her, she's safe again, I was fearful that she wasn't okay. Panic took over, and I couldn't say anything. I just screamed to try to attract attention and carried her upstairs.
And I heard John scream. And I said, what? You know, what is it? And Barbara, my friend, just, grabbed me and said, no, just stay right here, wait.
And I see John Ramsey carrying JonBenet up the last 3 steps from the basement. And my mind exploded. And everything that I had noted that morning that stuck out instantly made sense.
So last time we talked about the article with Alan Prendergast, and if I can remember it correctly, the name of the article was JonBenet Ramsey, How the Investigation Got Derailed and Why It Still Matters, written in 2014 originally, published 2014 originally, and sort of updated in November of 2014. Of course, talking about the murder of JonBenet Ramsey in December of 1996. And so that's the article. Once again, JonBenet Ramsey, How the Investigation Got Derailed and Why It Still Matters by Alan Prendergast, that we've been reviewing. Now, I said there were a few derivatives that came from that I wanted to follow up on. And one of them was more information about the grand jury process that we can kind of infer from what we were told and what we maybe have seen in some of the recent articles or some of the articles and things of that nature. So I prepared here a little report, and we're going to jump to different things. So if we get a little jumpy, please forgive me. So once again, want to shout out to everybody. Still going through comments and stuff like that, but want to say I appreciate everybody's support. Saw a couple comments. I don't want to say them right now because I want to line it up. Everybody shouting out where you came from, where you're from, and stuff like that. I love that. Appreciate that. Keep doing what you're doing. That's awesome to kind of see so many people from different places tuning in, stuff like that. Not only nationally, but internationally and stuff like that. So thanks once again for tuning in, and let's get started. So in October of 1999, Boulder County District Attorney Alex Hunter held a press conference to announce the conclusion of the grand jury proceedings in the JonBenet Ramsey case. His statement was carefully worded, indicating that the prosecution team had reviewed the evidence and concluded that there was not sufficient cause to warrant the filing of criminal charges at that time. To the public and most media outlets, this announcement suggested that the grand jury had chosen not to indict John and Patsy Ramsey. However, Hunter omitted a crucial fact that would not surface for another 14 years. The grand jury had, in fact, voted to indict both parents on 2 felony counts each. And Alan Prendergast mentioned that in his article. And in fact, we read the article by Charles Brennan from the International Standards of Barristers Society. His article in that, and this stuff is, I mean, it's on the internet, so I'm not, you can go and examine it if you would like, stuff like that. But we just review it here. Charles Brennan also mentioned something about that in that article, or that article, if I'm remembering correctly as well. And I think several other articles, CNN, British broadcast. They mentioned it. I mean, the History Channel, who didn't? They mentioned that there was sort of, years later when they found out, and I think Charles Brennan was one of the ones who pushed for, got wind. People got wind. It wasn't that it was going to be revealed because Alex Hunter just shut it up, and people got wind of it and said, "Well, is this true? Is this true that you guys did actually?" Because we've been led to believe that you didn't indict the Ramseys, but is it true that there was an indictment and then you chose not to file with the courts, even though, as we said in the last episode, you had 3 years to do so. So you had 3 years of time to investigate this. And so that's when sort of the floodgates kind of opened. Judge Lowenbach didn't want to release everything, but he just released the charges to say, well, yes, there are some charges. And so kind of moving through the report, and like I said, I'm going to jump around a little bit. Um, I'm skipping some things. So the jury had indeed signed true bills, and Hunter's public statement created a legal and political smokescreen, is what it did. And so this report in and of itself is kind of short, but anyways, in 2013, the long sealed grand jury indictment was finally made public, revealing that John and Patsy Ramsey had been indicted on 2 felony charges. The first charge was child abuse resulting in death, class 2 felony under Colorado law. Second charge, and you may not be able to see this, so I'll try to make it as big as I can without losing everything, but I just kind of highlighted this in a different color to kind of get my attention. But the second charge was accessory to a crime, specifically hindering the apprehension or the prosecution of the individual responsible for JonBenet's death. Now, let me make this a little bit smaller again. I'll keep reading. The statute of limitations plays a crucial role in criminal law, serving as a legal deadline by which charges must be filed for child abuse resulting in death. The applicable statute under Colorado law is 3 years, and that's CRS 16-5-401. And I have it pulled up here. It's kind of long, kind of lengthy. So if you're a legal head, you can kind of read through this. I'm not going to take up your time reading all through this and stuff like that. But just to show you that it does exist, and this is kind of what it looks like if you ever go digging. I think it's about 5 pages or something like that. And so, statute of limitations, limitation for commencing criminal proceedings, civil infraction proceedings, and juvenile delinquency proceedings. Definition: except as otherwise provided by statute applicable to specific offenses, delinquent acts, or circumstances, no adult person or juvenile shall be prosecuted. Okay? Except as otherwise stated. Basically, unless there's some other law out there, that prevents this law, the way to go about this law is as follows, is essentially what this is saying. So, except provided by statute applicable, and the statute has to be applicable, specific to specific offenses, delinquent acts, or circumstances, no adult person shall be prosecuted, tried, or punished for any offense or delinquent act unless the indictment, information, complaint, or petition in delinquency is filed in a court of competent jurisdiction, or a summons and complaint or penalty assessment notice is served upon the defendant or juvenile within a period of time after the commission of the offense or delinquent act as specified below. So basically, they're about to give you the time frames in which, and some of you have read this before, so you're familiar. They're about to give you the time frame in which, after you sort of maybe indict someone, or you call somebody out for something, a crime, or say, hey, we think you did this crime. Here are the things that we think you did. You have a certain amount of time to file that, as Alan had pointed out. And here, um, for the following reasons of murder, kidnapping, treason, any offense, I'll call it intimate abuse offense against a child, um, any improper intimate abuse offense against a child, and any forgery, regardless of penalty provided, no limit. So basically, all of these things have no limit in terms of statute of limitations. You can't go the rest of your life and think that you've gotten away with something. You can still, if they find evidence of these things, they can still bring you back and say, boom, um, you have committed these crimes. And it's funny to note here that John was trying to call in the cavalry. I think this has been in place. Correct me if I'm wrong. I think this has been in place. I think this was in place in 96. I'm thinking. Correct me if I'm wrong, but I think this was in place in 96. So what my point is that John was calling in the cavalry and saying we need to call in the Russian army. We need to shut down all the airports. We need to send out the U.S. military. We need to bring all of our arms to bear. We need to change policy. We need to do all of these things because let me tell you something. The charge that the BPD wasn't doing a good job wasn't just sort of an indictment against the BPD. It was an indictment really against the entire city of Boulder. It's like basically saying, you small town people here in Boulder are nothing. You guys don't know how to do anything. You guys are too small. You have this podunk, whatever investigation this podunk investigation or way about investigating crimes. You guys are not real professionals, and so therefore we can't trust anything that you are doing. That's disrespect to Boulder, because Boulder is saying, well, wait a minute. Police officers are our family. You know what I mean? Like the BPD is our family. We haven't had any problems with the BPD. For all we know, the BPD is keeping us safe. So I don't know what you're talking about in terms of murders, 15 or 16 within the last 5-10 years. I mean, they've solved 13. That's pretty good. So that tells us, even though, I mean, you can't make people commit murder. You know what I mean? Like, why are we getting mad at the Boulder Police Department? You're mad at me because my town is safe? Oh, you don't have a lot of experience with this, because we don't have people committing this crime. Like, what? Why is that a problem? Why is that an indictment against me? It's like, oh, man, dude, I just don't think you have it. Should we have more murders going on in our town? What are you talking about? Doesn't make sense. And so you're like, oh man, you guys don't have any, and you're saying that in reference to Atlanta. Is what you're trying to? That's the point that you're trying to make. Oh, Atlanta would have been on this. Atlanta would have done this. They would have done this better. That's the point that you're trying to make. And so, getting back to my original point, I said all that to say that Colorado already had that here. While you're trying to be disrespectful, Colorado already had. If there was an issue or an offense against your child, Colorado already had that here. They're going to say attempt, conspiracy, or solicitation to commit murder, attempt, conspiracy, or solicitation to commit kidnapping, attempt, conspiracy, or solicitation to commit treason, attempt, conspiracy, or solicitation to commit any acts offense, any act offense against a child. Anything, no limit. That means we're going to come back and get them. Whatever we got, we're going to bring it to bear. We're going to lay it on the table. So look, from the very beginning, we're interested in protecting our children. They already had that statute in the books. And John is out here telling people, because not only is John telling people that the BPD are not using resources or what have you, he's also now saying that the city of Boulder, Colorado, they don't got law, they don't got any codification for things against children, is essentially what he's saying. And so that was his entire campaign, that he was trying to run on. If you guys remember their PR preparation, and then he went on the campaign. That was probably the basis of his entire campaign. Is, oh, vote John Ramsey, for whatever he's running for in Michigan, I believe it was. I think he was running for a seat in Michigan. It was like, well, vote for me because I'm going to bring this, and we need laws that say this and do this and that and so on and so forth. When actually the FBI also had laws to kind of address this issue as well. If you do this across state lines, on federal property or what have you, then we're on that. They already had the law there. But John is running around saying that there is no law for this. And it was like, well, yeah, I'm pretty sure we can find something that, I mean, specific to the weird situation that you're in, that people may seem to suggest that you created. I mean, I'm pretty sure we can find something. I mean, but in terms of the framework you're referring to, we have something. So it's already here in the language. Vehicular homicide, except as described in subsection 1A.5 of this section, leaving the scene, blah, blah, there's 3 years. Leaving scene of an accident resulted in the death of a person, 5 years. Other felonies, 3 years. And so when we talk about other felonies, we are specifically talking about John in terms of being John and Patsy, in terms of being an accessory to a crime, which is what they were charged with. They were charged with child abuse, which attempt, conspiracy, solicitation to commit an offense against a child. I believe that has no limit, so they would have gotten hit under no limit if they were in on that. But if it's anything else like the accessory to the crime, it's probably going to be 3 years. And so you have no limit to file for the abuse part, I don't think, if they committed the abuse directly. But if they were an accessory, because they were charging them for being an accessory to those things, I believe. Child abuse and child neglect, I think you might be able to argue, but you'd have to prove attempt, conspiracy, or solicitation. You might be hard pressed to prove solicitation, even though that's what is being suggested by people who hold up the theory, like Stephen Singular or the Zell brothers, and they would be sitting under solicitation, that JonBenet was solicited out, would be their theory. And then there would be conspiracy there, an act of conspiracy, in that you conspired with people within the city or the town to let this happen to JonBenet, is essentially what they're saying. Or an attempt. Attempt would be by them or someone else, or what have you. So it can kind of get muddy from there, what is pinned on who and stuff like that. But there's no limit on that. So if they were trying to pin that on John or Patsy directly, there's no limit. But in terms of other felonies, like the accessory part, I think, which the accessory could be a class 4, 5, or 6 felony, in which, from my understanding, a class 4 would carry like 2 to 6 years of I guess I'll show you what I'm talking about in a minute. Class 4 felony would probably carry, I think, correct me if I'm wrong, 2 to 6 years in prison, 3 years of parole after release, and maybe fines between $2,000 and $500,000. And what falls under that is the accessory to a class 1 or class 2 felony. Like you're an accessory to that. Class 5 felony, which they could also be hit with, that would carry a lesser sentence, 1 to 3 years in prison, 2 years on parole after release, fines of $1,000 to $100,000. Accessory to a felony that is not class 1 or 2, or helping someone suspected of a more serious felony, falls under that. And some examples also include criminal negligent homicide and class 6 felony, punishable by 12 to 18 months in prison. Could be up to 3 years with aggravated factors. But just in general, 12 to 18 months. 1 year parole, fines of $1,000 to $100,000. Accessory to a class 6 felony is what's listed under that. So anyways, there being that would fall under the other felonies here for 3 years. And so basically, when Alex Hunter stood up there and said, "We don't have any evidence," and he basically said, "We're not going to follow up on this," um, half of the charge fell here, I believe. And so you got 3 years to file that. Um, it could be argued that the full charge falls under this. It could be argued. And so therefore you have 3 years to file that. And so after 3 years, John and Patsy are in the clear on an accessory and child abuse and child neglect, if that child abuse and child neglect is non-intimate, we'll call it. They get to fall under the 3 years. Okay. So this was the problem. Alex Hunter knew this. He was well aware of this. And instead of getting a move on, and instead of picking up the pace, you had 3 years to do it. And you had 3 years to do it, but you didn't move forward with it. While prosecutors are granted wide discretion, that power must be exercised ethically. The American Bar Association's Model Rules of Professional Conduct, Rule 3.8, outlines special responsibilities of a prosecutor, including disclosing exculpatory and material evidence. Exculpatory evidence is like, something about the case that, would exonerate my clients, and you're withholding it. You got to, your responsibility as a prosecutor is to say, we do have evidence that would, exonerate your client, or would, show that your client is innocent. And so therefore you need to be disclosing that. You need to disclose that. And I think that's the entire report. Before I jump into anything else, I want to go back up to a point, and I want to read through that to kind of get the basis of where we're going. This part right here, though. This part right here. Because I was thinking, I was like, how could you go 13 months and you say, we don't have anything. We've looked here, there, and we looked everywhere, but we don't have anything. How could you do that? And you say, because and like I said, I have the articles pulled up here, some of the articles pulled up here. You say, we have enough for probable cause, which is all you need in the grand jury proceedings. We have enough for probable cause, but we don't have enough for reasonable doubt. Probable cause is a lower standard than reasonable doubt. And so I'm saying this, we're saying this in terms of what may have been going on in terms of talking about the grand jury proceedings. And what the general format was probably that Alex Hunter comes in, presents his case, and then he kind of hands out some of these legal templates, if you will, to say, okay, here's what you can charge under these cases. Here's the guidelines for charges under this, what we might be presenting, charges for this, what we might be presenting, and so on and so forth. And we're going to call these witnesses for this purpose, and just kind of lay out this case. And there's a lot of understanding that even D.A. Lacey and Alex Hunter and D.A. Lacey were proponents of the intruder theory. The problem with this second charge, though, is that I call it being accessory to a crime, specifically hindering the apprehension or the prosecution of the individual responsible for JonBenet's death. Here's the critical part. They are specifically hindering the apprehension or the prosecution of the individual responsible. I think this is it. CRS 19-2.5-103 jurisdiction, except otherwise provided by law, the juvenile court has exclusive original jurisdiction in proceedings concerning any juvenile 10 years of age or older who has violated any federal or state law except non-felony state traffic, game and fish, parks and recreation laws or results or rules. The offense specified in the above section or what have you concerning the illegal possession or consumption of alcohol, marijuana by an underage person, so on and so forth, blah blah, to do with natural medicines and medicinal things and medicinal infractions. Basically, what this is saying is that in this little section right here, Colorado, because this is Colorado law, Colorado doesn't have jurisdiction of people under 10. And basically, what they're saying is that if you're under 10, we can't prosecute you for any reason, is the standard. So if there was ever a thought that Burke did it, you can't even bring that up. You can't prosecute that. I think, as I understand it, there could be cases in which you might, if you were to say that Burke did it, and let me say this, if you were to show that Burke did it and you had proof of that, you could not bring that to court. There would be no court proceeding for that because at the time he was 10, or he was under 10. I'm sorry. At the time he was under 10, barely. He would have turned 10. If he would have turned 10, he would have been fair game under this. If he would have turned 10 by the time this happened, all bets would have been off, and they would have probably had to get a lawyer for him. And so this is why John and Patsy did not have to get a lawyer for Burke. Because I was wondering, I was like, why didn't John and Patsy get a lawyer for Burke? Because they didn't have to. Because their lawyers would have known that under this Colorado law, this Colorado statute, that Burke could not be charged or considered in any crime. And so and so that's why John was mad. He said, hey, Commander Eller, he said it in his book, Commander Eller he was kind of referring, he was kind of this idea suggesting, according to my estimation, he was kind of saying, this Commander Eller guy is kind of foul. It's kind of messed up because he went and talked to my child behind my back. He went and talked to Burke behind my back, and that's illegal. You can't talk to Burke. And so that's what we say, when it comes to stuff like that, because John don't know a lot of things according to what John says. I haven't seen the report. I haven't seen the autopsy report. I haven't seen this. We haven't talked to pathologists. We haven't talked to gastroenterologists. We haven't talked to anybody. We've only gone off what we heard from our experts and our private investigators. So, we don't know anything. But y'all know enough. Somebody told y'all enough to know that they don't need to be talking to your kid without your consent. And John is very protective of that. He's very specific to mention that. That means something. You cannot talk to my kid. Why not? Why can't we talk to your kid? The difference is, if we were to try to compare this to the Elizabeth Smart case, the difference is that Elizabeth Smart's sister, I think she was 12. I think she was. I lied. She was 9. Any rate, she was 9. And so basically, the parents had to give permission. I think her name. What was her name? Kathleen or something like that. I think it was. Mary Catherine. Yeah, Elizabeth Smart, and you had Mary Catherine, the 9-year-old sister. Mary Catherine was 9, and so the parents gave permission to speak to the child, gave the permission. And so there is no difference then. It's the same. Your son is now 10. Give permission to speak to the son so we can solve this case. And so as we've pointed out here, that is a big difference. that might suggest that you're hiding something. And so you're saying, look, I know the law. I know you need me to talk to my child, and I'm not going to give you permission to talk to my child in this matter for the JonBenet Ramsey case. And when we uncover all of this evidence, when we look at all of this evidence, you start to wonder, well, wait a minute. After we go through all we've uncovered, why won't you give me permission to speak to Burke immediately? Why won't you? Oh, we're just trying to protect him. He's had a traumatic event. I mean, yeah. What's more traumatic? If let me say, you make the help me make the case here, and tell me if I'm wrong. What is more traumatic? Burke was supposedly laying in his bed, according to John and Patsy. He was laying in his bed. He didn't get up all night. We are going to scratch the fact for this specific situation. We're going to scratch the fact that Burke said that he, on Dr. Phil, that he got up after John and Patsy went to sleep. We're going to scratch that. For these purposes, let's say that Burke stayed in bed all night. Let's say that. Burke didn't see anything, right? So what would Burke be traumatized by? Huh? What traumatic event? Oh, they're losing his sister. Yeah, but he didn't see it. So what traumatic event would there have legitimately been to sort of say yes, or what would have happened to him to say, because he didn't hear anything, according to you guys, didn't hear anything, didn't see anything. He didn't even come out of his room to know that his sister had been abducted. And when he did, all he saw was cops. All he knew was his mom came in and said, "Where's my baby?" Now, what that's in connection to, you can't know. And then you say you saw an officer come in, but you didn't really want to know, according to what you're telling us, Burke. I didn't really want to know. Okay, that's fine. But that means that you didn't go through any trauma, really, right? You didn't go through any trauma. You didn't see anything. You didn't hear anything. There's no trauma other than the fact that I have a concern that my sister is gone. Other than that, there's no trauma, right? Right? But Mary Catherine, who laid in bed, what was it? They said a weapon, right? A weapon pointed at them. Dude came in with a weapon, snuck through the window, came in with a weapon and said, "You talk, you're done. You talk, your family's done." If I'm remembering the story correctly, I may be a little bit off, but the gist of it, I think he had a loaded weapon. Let me call it that. He said, "You talk, your family's done. Get up and come with me." Mary Catherine was laying there the entire time, watching. She watched her sister be held at point. She watched her sister be held and forced against her will to get up, knowing it, and Mary Catherine knew it was wrong. Probably knew that it was something that mom and dad warned them about. Probably something that you saw in the movies and on television that you never dreamed would happen to you. So I knew it was wrong. I knew something was up. And so I collected in my mind and stored in my mind. This is a 9-year-old now, because we have John and Patsy sitting in interviews talking about what they don't know. I 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 don't know. Never seen it. Can't recall. That looks weird. That looks strange. Can't really tell you. I'm not sure. Don't know what to tell you. They're sitting up in interviews doing that. And Burke is kind of doing the same thing. I'm not sure. All I remember is, but Mary Catherine sat up there and said, "There's a dude that came in and he pointed the weapon and he told my sister, get up." And then, they got up and he took her out and they went out the window, or what they went out the room. And then I waited, and then I played like I was asleep until the coast is clear. This is a 9-year-old who had the mental capacity to know she was in danger and know her sister was in danger and stay there. She didn't scream. She didn't holler. She laid there with her eyes fake closed, but she kind of had them open just a little bit. to try to see. I'm trying to see if I can, but I'm also hearing, I'm listening, but I have the mindset to play sleep. That kind of information, we need that. So that's trauma. And through the trauma, the police came and said, "Can we talk to your daughter?" That's what Ron Walker said. FBI agent said, even though there's a little bit of trauma, you got to ask them to give us anything that they can recollect. And Elizabeth Smart's family did that through trauma. But on the other hand, John blocked it. And not only did he block it, dare I say, they vociferously opposed it. Because that's how John does. When they asked him, "Hey, we saw some fibers, possibly from the shirt that you gave in JonBenet's," no, you didn't. No, you did not. For you to even suggest that it was me, absolutely not. It makes you lean back and say, why would you stop us from talking to Burke, somebody who might be maybe a treasure trove? Now, let me say this, because what's the problem? We highlighted this with the friends, but what would be the problem with talking to Burke? Why do we need a grand jury to talk to Burke if Burke, why couldn't we talk to him earlier at at our will if he don't know anything? You see what I'm saying? What would he tell? That's what I'm saying. I'm confused. You guys didn't want to give an interview, and you said because your lawyers told you not to. And Mike Bynum is telling us that it's a special circumstance as to why you can't talk. And then you're telling us Burke can't talk. And then you're going and getting an attorney for your ex-wife and your older children who weren't even around. I'm confused. What would they be saying because they weren't there? What would they know? They would just simply say, "I don't know, I wasn't there." Burke would simply just tell us what he said on Dr. Phil. "I don't know. All I can tell you is what I can tell you, and I wasn't there. I didn't hear it. I didn't hear anything. I didn't see anything. I wasn't there." So why such a long delay in allowing us to talk to Burke? Because if I'm getting back to this, it could suggest that maybe he knows something, possibly, just possibly. Not accusing him of knowing anything. I'm just saying it might suggest he knows more than he's letting on, possibly. But even if we push back against that, the second charge, accessory, that would require, if we're going to present something that might lead someone to believe that there is an accessory to the case, you would have to do one of two things. You would have to lead us to believe that Burke had something to do with this, and so John and Patsy were accessories to Burke. But according to the law, we can't do that because Burke is not considered a criminal at all. So you can't say that somebody is an accessory to a nobody. If you're presenting that somebody is an accessory to somebody, that means you have a specific identifiable person in mind, and you are presenting that specific identifiable person in mind. That means they were an accessory to whom? And as Alex Hunter, as the DA, as the defense attorney, as the prosecutor in this case, you would have been presenting whom? You as the DA know that Burke is under 10 and cannot be prosecuted. And so how could it be that John and Patsy, correct me on my legal status, how could it be that John and Patsy could assist him? if we were to believe that he was the actor. We couldn't. It don't exist. So essentially, we're saying that John and Patsy are an accessory to a John Doe unless you present an actual intruder. Who would the intruder be? It has to be somebody specific that we can name and say, this is the person. Because otherwise, we might have a problem when it comes to Rule 3.8, which is the special responsibilities of a prosecutor. Several things that I noted. The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. So if you're telling me that you presented an intruder theory, you and Mary Lacey, and you're openly claiming it, saying that you never thought that it was the Ramseys, at least that's what Mary Lacey said, and you're openly stating that, especially if we take Alex Hunter back to grand jury proceedings and you're allowing the intruder theory to be presented, you're saying that it's somebody else, but that would mean that you're going in with probable cause of someone other than Burke. Has to be, because Burke is a non-factor. He doesn't exist in this case. Can't even touch him. Can't even touch it. Can't even talk about it. So who exactly are we talking about? Who do we have? John Marcar has not come along yet. I think Helgoth he's done for. I'm not sure about Gary Oliva. Not sure about Santa. Bill McReynolds. Not sure about Linda Hoffman Pugh. But if I were to look at the grand jury documents, transcript, I should see that it is a consistent pattern from A to B, that Alex Hunter was presenting accessory of John and Patsy Ramsey, accessory to so-and-so specifically named, is what I should see. But I wonder if I would see that. I wonder if I would. Part B. So you have to refrain from prosecuting a charge, which would be the second charge, because that's what I said. This is what I said about that. This is what I said about the charge. I said, this part is bull crap. And we see specifically what Alex Hunter wasted time presenting. This is what was hard to prove, specifically because we don't know in terms of the grand jury who did it, right? When you don't have a suspect, then you can't prove this indictment because we don't have a specific intruder. We don't have anybody on the hook to say, hey, this is who we're going to look at. Let's go with them. So you don't have that. We don't have a kidnapper. We don't have an intruder. We don't have a friend. We don't have a family member. So if we don't have anybody that we're targeting, this charge is a useless dead end. Why would you present something that is a useless dead end charge when you know that from the beginning you're going into court? The police didn't tell you this. We know that coming from Steve Thomas. The police did not tell you this. So the police didn't put this in your mind. Who would have given you the accessory charge unless the police said, we think it was Burke? But you know, even if the police said it was Burke, that you cannot prosecute Burke. You know that. So who would you be putting accessory to the crime on? And this tells you what Alex Hunter was trying to focus on. That's wasted, and you would never even think about using a grand jury if you're coming with some stupid bullcrap charge like that. When that is prosecuted, you already know we have a weak case. This is a weak case from the very start. we have used the grand jury, and that lets you know we've used the grand jury. Now, the abuse part, we might be able to get behind. But this stuff with the grand jury, that's got me a little thrown off in terms of this second charge. Because we can't consider Burke, so that means that if you went and presented, then you knew of somebody or you were thinking about somebody, which I don't think you did. Part B, before I move on to my other notes. The prosecutor in the criminal case shall make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given reasonable opportunity to obtain counsel. Of course, John and Patsy Ramsey, get your counsel, do whatever you need to do. Part D, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order or of the tribunal. What this is saying is that if you know some information that says that they're not guilty, then you need to release. Now, that's in discovery. That's in the discovery phase. If you're actually going to file charges, from what I understand, that's in the discovery phase. If you're actually going to file charges and take John and Patsy to court, which is what John and Patsy said they were gearing up for. They said, we didn't know what was going to happen. We'd already signed over custody rights of Burke. We were fully expecting to be charged and arrested. So, we were trying to gear up for that. And the second part mitigates the offense. So the mitigating offense here, mitigating factors, from what I understand, from what my research tells me, is that if there is something that says, yes, they did it, but there are mitigating factors, like we did it under some sort of duress, or we did it under some sort of emotional draw, or something that should be also taken into consideration by the judge, and there's no protective order against me saying this information, you cannot withhold that. You have to say it. You have to be upfront, and you have to be honest and say, yes, we brought that up, and so on and so forth. We brought that up, and we did it for this purpose, blah, blah, blah. It could be that John and Patsy did it for this purpose, so on and so forth, because that might help with the leniency in sentencing. And like we just talked about, the different classes of felony charge that could be the case from going, like, having somebody that could be charged for in sort of sentenced to 2 to 3 years, from 1 to 3 years, or maybe 12 to 18 months or something like that. That could mean the difference in that if the judge says, okay, I found that you did do it, but you did it under this sort of duress, and so therefore that's what that's talking about. Part E, the prosecutor shall not subpoena a lawyer in a grand jury or other criminal proceedings to present evidence about a past or present client unless the prosecutor reasonably believes. So the prosecutor cannot ask the lawyer or the defense team of the person, of the criminal or the client, to come forward in a grand jury proceeding, except if the prosecutor believes the information sought is not protected from disclosure by any applicable privilege. That means client attorney privilege. If you believe that you're pulling the lawyer in the grand jury proceedings to talk about something that is not protected by client attorney privilege, you can subpoena the lawyer to come in. Number two, if the prosecutor believes that the evidence sought is essential to the successful completion of an ongoing investigation or prosecution, if you believe that you can come in, if they can come in and it's like, this evidence, we need this. My first thought on this is that the police said we need to use the grand jury proceedings in order to make John and Patsy talk. That was the entire reason. They wanted John to talk, they wanted Patsy to talk, and they wanted Burke to talk. Now, what you might have in this case are derivatives of people, are derivative witnesses, which would be Haddon, Morgan, Foreman, Pat Burke, and the private investigators and the media team. Those would be the people that you would subpoena to talk in this trial. Even if you know that some of these people are going to plead the fifth, you would subpoena these people to talk because we are trying to find out evidence that is essential to the successful completion of this ongoing case of JonBenet Ramsey. We saw last video, at the beginning of the video, when Alex Hunter said he tried to make an excuse. And I was ticked off about that ignorance. He tried to make an excuse to say, oh, we had waited until the case had stalled. The case had stalled in April. The case didn't stall in April. The police had been trying to get John and Patsy to come in and talk since January, since December. They had been trying to get them to come in and talk. And none of you guys would step in and subpoena them in any kind of way or use your prosecutorial powers to make them come in. Because you said, oh, they're the lawyers, they don't have to do anything. Okay, I got that. I'm with you on that. But there is no stall on the police's part. They cannot force them to come in. They were asking them to come in. John said, I will come in. John told Fleet, according to Alan Prendergast, John told Fleet, I will go in and talk to the police. We're going to go and talk to the police. As soon as we get back, we're going to talk to the police. And John went on national television and said, when we get back, we're going to talk to the police as soon as we get back. And they never did for 4 months. Whose fault is that? So when you try to turn around and say, oh, the police did it, they didn't. No, they didn't. They tried. They couldn't get the people to come in. They couldn't compel them to come in. And so we need you to possibly subpoena these people in so that we can solve this ongoing case. And number 3, there is no other feasible alternative to obtain the information. If there's no other way that we can get this information, you need to call their attorneys in, and you need to be very mindful of this. This protective client attorney privilege. You need to be mindful of that. You need to be focused on that. But this was available to Alex Hunter in his proceedings, in his grand jury proceedings. This was available. You could have called in the attorneys, Haddon, Morgan, and Foreman, and say, what do you know? You could have called in Mike Bynum and said, what do you know that pertains to this case? Because Mike Bynum, for what we know, ain't under client attorney privilege. You can argue that once they hired Haddon, Morgan, and Foreman, that he's not under client attorney privilege. If he's a third party that's not officially on the team, you can argue that he's not under client attorney privilege. Because what's not protected, as I understand it, what's not protected under client attorney privilege is third party conversation. So if you have somebody like an investigator or a friend or the media, people who are going to be on the PR campaign that are in the room or on the email chain that are in the transcripts, those are third party people. And that is not protected. As I understand it, could be wrong. Correct me in the chat if I'm wrong. Those are third party conversations that you can subpoena and say, come on, bring that to me. I want to see it. We need to go through all of this and see what you guys are talking about. So how exactly did y'all end up on charges like this with only probable cause, but no reasonable doubt? Because you had plenty of people to talk to. You could have talked to their attorneys. You could have talked to their other family members. You could have called in Cindy. You could have called in Cindy. You could have called in everyone. I mean, this thing could have taken 2 years, if I'm correct. If I'm thinking correctly, this thing could have taken 2 years. And in the process, as we're going through this grand jury proceeding, it's not only to indict, but it's also to exonerate. So as we're going through these proceedings, we can say, Linda didn't do it, Bill didn't do it, Fleet didn't do it, Priscilla didn't do it, none of these three did it. Neither Susan nor Glenn did it. And you can kind of start really pulling out and saying, okay, This is unrelated. This is unrelated. Call in Hoverstock. Bring that letter. Call in Hoverstock. And if there's a ring going on in here, we need to either confirm it or we need to dispel it. Right here, right now. That is pushing this investigative tool to its limit. That is intentional use of pushing this investigative tool to its limit. And so we are clearly seeing that there was a hesitation, because this is what the grand jury, one of the grand jury people said. They said what we were seeing on television and what was being presented in the room was vastly different. It's very different. Basically, Alex wasn't presenting anything. The things that you would have questions about, we didn't see that in the courtroom. So it lets you know that Alex wasn't presenting everything that he had. You could have presented everything that you had. And this is the problem. And because I was asking, I said, well, couldn't they just basically have bogarted him and just kind of did an override of his his power as a prosecutor? Couldn't they just overrode that and said, you know what? No, we want to talk to these people. Subpoena these records. Subpoena this phone records directly from the phone company. Subpoena the credit card records directly from the credit card company. The problem becomes, as I understand it, and even calling on witnesses, if DA Hunter says, no, I don't think we have a reason to write the subpoena, he can shut that down. That makes the grand jury less it diminishes the power of the grand jury, basically. And they're not as powerful as I thought, because you still have a sort of constrictive control that stops them and says, you can go here, but you can't go here. And if you go here, I'm not going to help you. And what that seems to suggest to me is that it's consistent with Steve Thomas's point, in that the police were looking for some of those records. And we know that they didn't have those records, according to Lou Smith in the interview, when he said, we have some of this stuff, but we don't have all this stuff. Would you be willing to give us the rest of the records? And that was like 2 years later, almost. Year and a half, 2 years later, that they were finally going to get that. Like a year and a half, that they were finally going to get that. And that's when he asked for the fullness. A year and a half later is when he asked, prior to the grand jury in 99. No, I'm sorry, in 98. And I think in August of 98, they asked. So in June of 98. And then I think the proceedings started, I think, in somewhere between August and October, I think, if I'm just kind of pulling from memory. So they didn't get all that until sometime in 1998 or afterwards. And from there, we don't know what John and Patsy turned in. John and Patsy can turn, just like John and Patsy were telling us that they cooperated with the police, clearly knowing that they were being dishonest on national television, knowing that they had not gone in for an official interview, knowing that what people meant, what Steve Thomas meant. And John was reading off of the police report saying that they were cooperating, using very specific and targeted language to say that, no, we did cooperate. No, you didn't. Police were asking you to come in and they were chasing you down to come in, and you were not coming in. Because the first excuse you gave was, I'm not coming in because we're about to get this funeral out of the way first. Fine, fair enough. But now I'm asking, after this, are you going to come in? Your friend has asked you, are you going to come in? You jumped on CNN and said you would. Fleet and Priscilla tell a story that you said you would, but then you get home and you say, I ain't doing it. Get out of my face. We might talk to you through paper, through writings and stuff like that, but we're not going to give you a chance. And if we do, it's got to be here. There are going to be stipulations to this, right? You have to bring this person in, or you have to bring this person in, because we don't trust you. Now you are guiding the investigation according to you and what you want to show and what you want to put forward. That becomes a problem in light of all of these things that we see. There were plenty of opportunities. We talk about police bungling, huh? You had an opportunity to interview these people and you didn't. To use this knowing you knew the full scope of what the police wanted to do, and you didn't do it. You refused to do it. They had asked you twice, and this is the second time asking you. We want to use this tool to get to the Ramseys. Will you please do it? And John and Patsy running around here talking about, oh, we weren't ducking and dodging anybody. We wanted to talk to. Then Fleet was basically screaming at you, go do it, and you didn't do it. Now we got to start looking at you sideways and saying, why didn't you do it? What took you so long to get there? And that's the end of the rule. I did have a question about this. Except for statements that are necessary to inform the public of the nature and the extent of the prosecutor's action and that serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, and other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 or this rule. And so basically what I understand this to mean is that you don't want to incite the public into like sort of condemning John and Patsy any more than you have to. So you want to refrain. And this is probably what Alex Hunter would say. Oh, the reason I didn't mention the indictments is because that would have heightened the likelihood of public condemnation of the accused, of John and Patsy Ramsey. But I got to ask, I really do. It makes you wonder, who was the focus? If you thought that someone else did it in terms of the intruder theory, who was the focus of this grand jury presentation? Who was the criminal? Because it seems like it's all over the place. Because the accused should have been somebody outside of John and Patsy. But we know that according to the grand jury proceedings, it was probably John and Patsy. So we were never really focused on, that tells you right there that we were never really focused on JonBenet's killer in the grand jury proceedings. We were still focused on more off homicide behavior. And what I mean by that is that we're not directly addressing the main thing. We're addressing adjacent behavior. That is very telling, because why are we not looking for the person? Do we have access? What's the focus and the motive of this investigation? What can we prove? That alone might signal a problem. Why are we not looking for the killer? This proceeding is not based on looking for the killer. This proceeding is based on somebody assisting the killer. Okay. If we are going to proceed with an entire process to accuse, because we're not accusing John and Patsy Ramsey of committing the murder against JonBenet. That was never in the charges. That was never in the presentation. We're saying an intruder did it. If going into this proceeding, the focus of the proceeding was not to accuse John and Patsy Ramsey of murdering JonBenet, then that assumes that we're already aware of who murdered JonBenet. Somehow, some way, we have a pretty good idea of who murdered JonBenet, because if we didn't, I have to believe that there would be no reason for us to proceed in trying to charge somebody as an accessory when we don't know who they would be an accessory to. And so from that perspective, when we go through this part and we say public condemnation would be heightened against people who, why? Against people who did not kill JonBenet. Why would we even be conducting proceedings of that? So that already tells me that there is some sort of barrier that is preventing me from looking at the true killer. Why? Because you already know your case is weak if you don't have any person to pin this murder on. The case is already weak from the jump because we don't have the foundation, and we talk about police bungling. This is the highest level of bungling because the prosecutor fought against the police and said their theories were wild and unbased and unsubstantiated, and then promptly went into court with no basis or foundation for charging John or Patsy Ramsey with anything. You are a veteran prosecutor of 30 something odd years in Boulder County, in Boulder, Colorado. You know better. You know better. You know well more than better. This is the start of prosecuting something that you already knew. I have to believe that you already knew was weak from the beginning and was going nowhere. So instead of stating we're not at a place yet to use the grand jury, the stronger charge would have been abuse. We have medical records that we can look at, all such as that, so on and so forth. You can compel Dr. Buff to give you the records. Come on, bring them to me. Oh, I'm telling you right now, there's nothing in there. I don't want to hear none of it. Bring it to me. I'm telling you right now, there's nothing that I've seen. Give us the documents and the records, and we'll be the judge of that in terms of what should have been done based on the number of visits that JonBenet was dealing with. We will then determine, based on what Patsy is telling us, if there is a true substantiated claim of abuse or neglect in any way. That is a stronger claim because we have direct access. It doesn't involve anybody else except for John and Patsy that we can call and say, because then what John is telling us is that, yeah, all of my kids had this problem. Oh, so you knew that this problem was there, but you're telling us that you didn't know. But as a parent, you tell us that there's a history, which you talked about. Oh, there would have been a history. Well, now you're telling us that you have a history of knowing that your children use the restroom on themselves. And so we would dig into the claim of abuse or neglect there and see what we come up with. But it's specifically with Patsy digging into the claim of abuse and neglect, we would pull in Priscilla. We would pull in Priscilla and say, Priscilla, you gave Patsy this book because you had concerns that Patsy was possibly losing control of JonBenet in a way or being neglectful in some way. Is that the case? Let us know, yes or no. Maybe you did, maybe you didn't. But we just want to know, because I'm not trying to accuse anybody of anything. I'm just trying to ask questions of what the case could be. Because just based off of that fact alone, we got plenty of questions to ask. We got plenty of things to go off of. And the fact that we have a direction, a path, especially 3 years, especially within 3 years to touch on and say, well, look here, according to this felony, we got 3 years to prove it. There's a way that we can go with this neglect charge, right? We can go there. But this other accessory charge and doing things to shield the Ramseys would mean that we didn't even look at the murder charge. We looked at the accessory charge with no basis, like I just said. And we knew that there would be something in my statement that would cause more scrutiny, probably reasonably so, against the Ramseys. And so instead of letting people, especially your investigators, have a clear understanding about the truth of the case, you withheld information. Nobody made you do it. No one forced you to do it. You withheld the truth of the indictments from the people and possibly the police, and led them to believe that there was no indictment, or there was no, and what the indictment signals is that you led them to believe that there was no reason to believe that the Ramseys did this. Because through all of this, even though you don't have a person to attach it to, the grand jury, after 13 months, knowing, as the person said, let me find that one. And I do note that the person said in the basement, what is this? This is ABC, an article from ABC. It's page 4 or 5. Let me go back to the top so you can just see what article this is. Grand juror who saw evidence in JonBenet Ramsey case speaks out. ABC News is what that is. So again, grand juror who saw original evidence in the JonBenet Ramsey case speaks out. ABC News. And so, and they were kind of saying that, you know, we didn't know anything about the case and we thought it was discussing that JonBenet was involved in these pageants. In the basement where she was found, it was actually kind of an obscure layout. The juror said, you come down the stairwell and you had to go into another room to find a door that was closed. It was a very eerie feeling. It was like somebody had been killed here. The juror said he believes that there was enough evidence to indict John and Patsy Ramsey for a crime, but he doesn't think they would have been convicted. There's no way I would have been able to say beyond a reasonable doubt, this is the person, the juror said. And if you are the district attorney, if you know that going in, it's a waste of taxpayer dollars to do it. If you know going in that you don't have a killer, it's a waste of taxpayer dollars to even talk about a grand jury proceeding. If the grand jury people knew that there was only probable cause and not beyond a reasonable doubt, that means that at some point in time, what you were presenting, they said to each other, look, especially given the fact that John and Patsy were not brought in, especially given the fact that their lawyers were not brought in, their PR firm and their investigators were not brought in. I'm not sure. I know the kids were brought in, but I don't know if Cindy was brought in. I think Linda Hoffman Pugh was brought in. I'm not sure if Mervyn was there as well. And all these other people that you had an opportunity to bring in, and along with the other records that you could have used, that could have gotten them closer to beyond a reasonable doubt. It could have proved or disproved some of the things that the police were asking about and saying. You could have asked those questions specifically because you knew in a 2-day stretch what the police were wanting. And you didn't want to bring in Lou Smith, I believe, because you thought Lou may have made it look biased. Lou may have brought a certain level of bias to the proceedings that makes it seem like, hey, you're letting Lou in to present the intruder theory. What about any other theories are you considering? And that might have tipped your hand. So you got to fight Lou to stay out. But if Lou prevails, then you say, well, we had no choice. Lou prevailed and he won. And so we had to let him. You know, it's not that we wanted him to do it, but we had to let him do it. So Lou gets in and he's able to provide more credence to an intruder who would be the principal offender, in which John and Patsy would have to know. And this is the problem with that second charge. You cannot prove that John and Patsy know anyone, because John and Patsy have continued to tell you that they don't know. And you have not sat down with them enough for you have not, nowhere in the transcripts. You had the transcripts from their interviews in 97 and 1998 going in, and never did they tell you that they know who did it. And never did you find who did it. So you have yet to prove that. So going in, you're already wasting taxpayer dollars. Nonsense and foolishness, because you were well aware of what you did and did not have before you did it. Now we get down to the bottom of this little mess that you created. this little nonsense that you created, knowing you had a weak case. And then when the grand jury said, well, this is what we got, they knew they didn't have any evidence to stop this or prevent this. They knew they didn't have any evidence for anything because of what you presented. CNN put this together, and I'll touch on that in a second. This is court papers. Grand jury in 1999 sought to indict JonBenet Ramsey's parents. CNN. Investigators at the time were disappointed in the then district attorney's decision to not issue indictments, Beckner said. Cases are rarely perfect and often contain conflicting evidence. As a result, the opportunity to present the entire case to a jury may be lost forever. Exactly. That's what we're dealing with today. The opportunity to present the entire case suggests that Alex Hunter only presented part of the case, part of the facts. But we don't have opportunities to present all of the facts that we really wanted to present, that we needed to present, because Alex Hunter made the decision to omit some things on his own. While we believe at this point it's unlikely that there will ever be a prosecution, the Boulder Police Department still holds out some hope that one day the district attorney and the Boulder Police Department will be able to put together a case worthy of presenting to a jury. Beckner said, when you did this, and this is why you left office, because when you did this, you knew what you had done. When we talk about the 3-year statute of limitations, you knew what you had done. When you walked away from that podium, you knew exactly what you had done. You knew exactly what you were doing. When you chose that, and then you left office and hot potatoed it onto somebody else, on the Mary Lacey, you knew exactly what you were doing. And that's the problem, because you walked away, and because everybody was left with their head hanging. Said, man, we may have lost an opportunity to prosecute this case forever because we put everything on the line. And the fact that you did this, and you're not gonna bring charges, that means that all of that is going to be for naught. We can't use this information anymore. Beckner knew. He knew the ramifications of that. For a district attorney to not endorse a grand jury's charge is exceptionally rare, said analyst Craig Silverman, who was chief deputy district attorney in Denver for 16 years. It's exceptionally rare. It don't happen. So you got somebody in Colorado, in Denver, had been there for 16 years doing his thing, said, man, that's kind of rare. And this was written in 2013, I believe. But he said that's kind of rare for that to happen. Further highlighting just how off kilter, if I can say it that way, your decision was. Just how out of bounds, maybe that sounds bad, out of bounds, way off point, way off base, your decision was in not prosecuting this case or taking the grand jury's endorsement up. Why would a DA have a grand jury deliberate and vote if he's not going to pursue the charges that they bring back, Silverman said. And did the grand jury come up with those charges on their own? This is a prosecutor. This is a legal analyst in Colorado. Your boy. No way. One of the DAs had to provide that verbiage. Exactly. You were in control. That's the point that we're making. You were in control. Mr. Alex Hunter, you were in control of this. Somebody pointed to a video in which Michael Caine was sitting in the back, and I think this was on the Cold Case documentary. And they pointed and said you could see that Michael Caine was disappointed, and Michael Caine was like, man, I was just thinking about all the time that we had wasted. He was like, I wasn't saying that anybody was guilty. I was just thinking about all the time that we had wasted. If I remember what he said correctly, he was just like, this is so disappointing. A little girl is, we had done all this work and come up with nothing. is what I remember him saying on the Netflix documentary. If it came from there, if I'm remembering correctly, I think that's where it came from. But anyways, they said that Michael Caine was disappointed, and as we discussed in last episode, there were some other areas that Michael Caine disagreed with uh, Alex Hunter's behavior in certain instances. He was worried about Nancy Krebs. Um, Alex Hunter's worried about Nancy Krebs. He's giving credence to that, and Michael Caine is like, man, we have other things to be worried about. Let the police investigate that and tell us what they find, and then get back to us before we, you know, give any credibility or credence to that. Let's just let the police investigate that, see what they find, and then come back to us. Right now, it's just an opinion piece. But here we have Alex Hunter, who he and his team have provided verbiage for these charges that you're not going to pick up. And you know good and well what's at stake, and you know good and well that you already have a weak case. Now, let me take a look at my other notes. So here we have, let me see. Well, yeah, okay. This is an article. You can find this on the internet as well. We've looked at this guy's work. What is an accessory to a crime in Colorado? CRS 18-8-105. Once again, what is an accessory to a crime in Colorado? CRS 18-8-105. Let me make sure you can see it. Who can be held responsible for a crime under Colorado law? To establish that an accused is guilty of being an accessory under Colorado law, the following statutory elements must be proven. A crime has been committed. The accused rendered assistance to the actor. The accused intended to hinder, delay, or prevent the discovery, detection, apprehension, prosecution, conviction, or punishment of the principal. The accused knew that the person being assisted has committed or has been convicted of or is charged by pending information, indictment, or complaint with such a crime, or is suspected of or wanted in connection with such a crime. Number 5, the underlying crime is designated as a felony other than a class 1 or 2 felony. Accessory law, the actual accessory. Then there are the second category of participants, accessories, because we're not talking about somebody who's aiding and abetting. We're talking about somebody who's a legitimate accessory. It's sometimes referred to as an accessory after the fact, but you can only be an accessory after the fact. An accessory, being an accessory is its own separate crime under Colorado law. Is someone who, with knowledge that a felony has been committed, does something to help a principal escape capture, prosecution, punishment, or hides evidence, etc. For example, if you drove your friend to rob a bank, waited outside, and drove them away afterward, you're a principal under the aiding and abetting theory. That's not accessory to a crime. You're a principal. You actually helped commit the crime. If your friend came running to your house and told you they just robbed a bank and asked you to hide a bag of money, and you do it, you're an accessory. That's a key point here. You have identified a friend who has come running to you and said, hey, hide this. The defenses to the crime of accessory. For an accessory, they must prove you knew that a felony was committed and that you actively did something with the intent that a principal to the crime escape. The proof of knowledge is often weak in many cases, giving you defenses to the charges. And as we said, 18-8-105, a person is accessory to the crime if with intent to hinder, delay, or prevent the discovery, detection, apprehension, prosecution, conviction, or punishment of another for the commission of a crime. He renders assistance to such a person. To render assistance means to harbor or conceal the other, or provide such a person with money, transportation, weapon, disguise, or other thing to be used in avoiding discovery or apprehension, or by force, intimidation, or deception, obstruct anyone in the performance of any act. Deception, by force, intimidation, or by deception, obstruct anyone in the performance of any act which might aid in the discovery, detection, apprehension, prosecution, conviction, or punishment of that person. Conceal, destroy, or alter any physical or testimonial evidence that might aid in the discovery detection of these such things for this person. And this is where we went through the felonies. Being an accessory to a crime is a class 4 felony. Um, if the offender knows that the person being assisted has committed or been convicted of or is charged by pending information, indictment, or complaint with a crime, if the crime is a class 1 or class 2 felony, or being an accessory to a crime, or being accessory to a crime is a class 5 felony if the offender knows that the person being assisted is suspected of or wanted for a crime, and if that crime is designated as a class 1 or class 2 felony. And then being an accessory to a crime is a class 5 felony if the offender knows that the person being assisted has committed or been convicted of, or there are charges pending for this person, or is suspected of or wanted of for a crime, and if that crime is designated by class 1 or 2 felony, except that being an accessory to a class 6 felony is a class 6 felony. So you have to know the person, like we were saying. An accessory to a crime, no probable cause argument. In Rule 3.8a, a prosecutor shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. That means if you don't know it's supported by probable cause, we don't know who the killer is, or you can't bring Burke in. If you're suggesting to us that Burke did it, you cannot bring him in. So there's no probable cause there for this accessory charge. So I'm challenging the accessory to a crime indictment against John and Patsy Ramsey because you don't have a specific person who can legally be charged for the underlying crime because Burke is under 10 and you have no intruder. Therefore, you do ask the question, accessory to what? The underlying crime can't be legally named, but Alex Hunter did it anyway. I believe it's possible that that's a violation of these rules of conduct. Of the special responsibilities of a prosecutor, if we're talking about the way the proceedings went, I believe it's possible that that's a violation. Just based on what I'm seeing, it's possible that that's a violation. An accessory requires a specific principal offense. If no one can be named or legally charged, the accessory charge collapses. So we knew from the beginning when we made the accessory charge, when you gave them the template for the accessory charge, the charge had already collapsed. There was nothing to it. It's a waste of time. Since Burke couldn't be prosecuted and no intruder was ever identified, the prosecution had no legally prosecutable predicate offense, meaning probable cause may not have ever existed. And this might violate 3.8a if Alex Hunter knew this weakness but allowed or supported the indictment narrative anyway. Child abuse and neglect may have been the stronger charge. And so I pointed out that JonBenet had a history of unexplained issues, including vaginitis. No specialist was referred to, according to what we know. According to what John and Patsy said, we don't see a specialist in their interviews. We don't ever see a specialist recommended. And when Dr. Buff was given the opportunity to say something, he never told us that he recommended a specialist. And so arguably, this is neglectful conduct. Under Colorado law, this could support a child abuse or child neglect charge, possibly, especially in conjunction with the events surrounding her death, such as the actual intimate abuse. And this here may have been the cleaner theory, backed by medical records, parental omissions, and forensic evidence, and more legally grounded than the vague accessory charge. Number 3, failure to call John and Patsy might be an ethical and strategic breakdown. If we're looking at Rule 3.8, which requires, 3.8D. Sorry, here it goes. This one, which requires that the prosecutor make timely disclosures and not hide mitigating or exculpatory evidence or evidence that could exonerate somebody or whatnot, or lighten the load of that. Just tell people and stuff like that. And while Rule 3.8 doesn't explicitly require calling witnesses before a grand jury, common prosecutorial standards and basic fairness principles strongly suggest that John and Patsy should have been called even if they invoked the fifth, like we said before in other episodes. Their absence implies possible manipulation, what it really implies is incomplete proceedings, because you don't have all the facts. You don't have all of the evidence to go off of. We haven't heard from the parents. We haven't heard from the parents' attorneys. So we have an incomplete proceeding, and possibly designed to protect against exculpatory responses that might say, well, are John and Patsy actually, are they actually accessories to a crime? We don't know. You don't even give us the opportunity, because they might be legitimately innocent. You don't give us the opportunity to even look at that, to even clear them based on their testimony, to put it up against other facts. You don't give us an opportunity to say that. And so these could be exculpatory responses, right? Or to avoid grand jury exposure of investigatory weaknesses. Like if you're presenting the intruder theory, that might expose your intruder theory, and the grand jury might say, well, wait, if you're trying to say that there is, accessory to a crime, we got to name who the person is, right? Then that means that they know the intruder, right? Now, I tell you what, people who believe in the ring, the S ring theory, they would have a field day with this. If we're suggesting that you're not bringing in John and Patsy Ramsey because it's possible that there might be some investigative weaknesses, and that maybe they knew the person. That's what that means. Maybe they said something, they knew the person that may have come in. That might be a problem. Number 4, trying to subpoena the attorneys or private investigators under 3.8E, which is here in green. So kind of looking at this rule, which limits the attorneys unless information isn't protected by privilege. You have the evidence. Evidence is essential to completing the investigation, and there is no feasible alternative to obtain it. So, for example, if you have Ellis Armstead, who was, I think, the private investigator, one of the attorneys for Patsy, and then you have Pat Burke and attorneys at Haddon, Morgan, and Foreman, were likely involved in coordinating the defense and possibly access to some of the evidence that they may not be telling you. The grand jury could have, and arguably should have, subpoenaed these individuals under this to determine what was being concealed or maybe redirected, to establish why Patsy was being shielded from questioning, and because the Boulder police were actively requesting answers that could come from these individuals. So if the prosecutor chose not to call John and Patsy or their legal team, knowing there were no other reasonable or feasible alternatives, this could be a violation. I believe this could possibly be a violation of 3.8E, number 3, right here. We don't have any other alternatives. Let the grand jury call them and compel them to testify. You got to help them with that. Give them instruction on how to do that, and say, if you believe that John and Patsy have something to say, because how are we going to charge somebody without talking to them? Who would do that? Who would charge somebody without talking to them? That means that you would not let us compel these witnesses to come forward. That means that you would not subpoena these witnesses to compel them to come forward. Because why would somebody charge other people without hearing their testimony, when it's possible that, knowing that we have nothing but probable cause and we don't have reasonable doubt, we got to hear from John and Patsy to charge them with neglect? Where would neglect come from? Where would the neglect charge even come from? And then where would the accessory to this crime come from? Who would be presenting that? Failure to use the grand jury as an investigative tool. Colorado's grand jury is not just for indictments, it's also a fact-finding tool. Given, as we know, the request for help to gather testimony, use the grand jury to gather testimony, and the DA here seems to have refused to call key figures, including the Ramseys. The grand jury proceedings were closed, incomplete, and seemingly strategically limited. So in this case, it might be possible to argue that the prosecutor abused discretion afforded by Rule 3.8. Maybe. I don't know. Just theorizing here. Avoiding meaningful use of the grand jury, ignoring strategic leads, such as the John Mark Carr misdirection, declining to, if you could show that it was a misdirection, declining to subpoena those directly involved in the legal media defense, such as people on the Ramseys team, being used as a PR firm to kind of showcase something, and pushing a charge of accessory without a viable principal defendant. Kind of going deeper into that, walking through these different points, failure to call John and Patsy and that breakdown. And so kind of saying that not calling John and Patsy before the grand jury was a major failure, both ethically and strategically, because under Rule 3.8D, which is here in blue, a prosecutor has a duty to disclose any evidence that negates the guilt of accused or mitigates the seriousness of the offense. Because what we're saying is this: they might be innocent, they might be guilty, or they might be guilty, and it might help us explain what happened. It might cast doubts on the narrative of the intruder theory being presented, or it could correct investigative blind spots, which is what the grand jury was being used for. But that's what we are trying to use it for, because we are trying to correct these blind spots and say, hey, we don't know all the information that we need to know, and we need to be able to connect the dots. Can you call these people in so that we can connect these dots? And you knew going in that this is what we needed, and you refused to do it anyway. And so what you could have done is you could have said, okay, the police are saying this, we can find this, whatever. And so you had the opportunity to do that, use the grand jury for that tool, didn't do it. Of course, exculpatory being the idea that a fact that contradicts a key accusation, you have a medical record that shows innocence, or a witness statement that gives the accused an alibi, or even statements from the accused that might clarify or reduce suspicion. In this context, we can think about if John and Patsy had testified and had given plausible, innocent explanations for key forensic evidence or timeline issues. This is something that this is a reason why the Boulder police, not the DA, who let them go, this is why the Boulder police were trying to hold on to the body, because they were trying to get an understanding of the key forensic and DNA evidence, or the key forensic evidence as in the timeline issues as it related to JonBenet's body. We could have, these were all things that we needed to understand and ask about. All things that would have been perfect to ask about. Or said something under oath that diluted and the opportunity to get him under oath. My God. Who do you think messed up this case more? The Ramsey, the police, or the DA? Because I'm starting to think it was the DA. This is bad. Or said something under oath, because you could have got him under oath, that diluted the DA's theory that would be exculpatory, and the DA would have had a duty to disclose it to the defense in any future cases. So if we come to the understanding that this intruder theory is not possible, we gotta shut that down. That's how I'm taking it. Obviously, it could mean other things in terms of claiming John and Patsy's innocence, in terms of killing, in terms of the murder of JonBenet. That could definitely give us insight and say, well, we know that John and Patsy didn't murder JonBenet. What was their role? And we can say for certain we know what was the role, because some people still have questions about whether they actually did it or not. And we could just move on to what was their role then if they didn't do this. subpoenaing attorneys or private investigators, asking specifically what specific information in this case might not be protected by attorney-client privilege and therefore could have been subpoenaed. Confidential attorney-client privilege, attorney-client privilege protects confidential communications between a client and their lawyer, and communications that are made for the purposes of legal advice, as long as no crime or fraud is being committed. But as I understand it, not everything a lawyer hears or knows is protected. I think that has to do with fraud. So in the case, things that might not be protected is a statement made in public or to third parties. If John and Patsy told their lawyer something in front of a third party, like a PR advisor, like a private investigator, like Ellis Armstead, or a media rep, that might not be privileged. Now, the fact of certain actions, privilege doesn't cover acts the lawyer takes, only private communication. So if an attorney coordinated the media strategy, directed someone to plant or move evidence, which I'm not saying anybody did, helped script a story for media appearances, or was involved in coaching testimony outside a protected setting, those actions may not be protected and could be subpoenaed. Like I'm thinking maybe something with some things with Mike Bynum. I'm thinking not everything was protected is what I'm thinking. For example, if Patsy's attorney had conversations with investigators or the media about suppressing evidence, feeding it misinformation, or delaying cooperation, and those conversations weren't directly legal advice, they may be subject to subpoena. So if we're looking at somebody like a Had Morgan informant or Ellis Armstead, we might be able to argue that Armstead, as a private investigator, may have collected evidence that was not protected by privilege if it wasn't used for legal defense, it was shared with others, or it involved actions beyond legal strategy like press management or evidence. If John Ramsey told his lawyers to leak information about Sue Bennett Jameson, or to coordinate with Susan Stein, and those communications can be shown to be a part of a sort of like a conspiracy of sorts or whatever, you might be able to invoke something like crime fraud exception, in which you could override, which removes that privilege when legal services are used to further a crime or fraud. This is my understanding. I could be wrong. If you're a lawyer, check me in the chat. You know what I mean? And so what I'm saying is, if there was a case, and I think that's more in my notes, if there was a case that there was like crime fraud somewhere, we would have to work backwards to say, okay, I have a sense that there might be some fraud somewhere. What's going on with that? I could look at that, okay? And that would bring about looking at things like, say, for example, you have emails, if you have emails between, and looking at things specifically that you can subpoena, which we're still looking at, or we're looking at part E, subpoenaing these things, trying to subpoena this communication, emails between John and Patsy and Ellis Armstead, or if they weren't acting solely as legal agents, PR firm records, emails, memos, prep documents, especially if they contain reference talking point, contain or reference talking points, scripted narratives, coaching about media responses, communications involving attorneys, clients, and third parties that are not protected in any meeting notes or recordings that include third party in the room. So if the PR firm was retained by the law firm, it doesn't automatically make them underprivileged, that I understand. The context and the content may matter. And so here, if John and Patsy told attorneys one thing, if we're working backwards to say, okay, what's fraud? Can we kind of dig in, because you can't get the I think you first have to show that the client attorney privilege was fraud. You have to work backwards. So if John and Patsy told the attorneys one thing, we think this individual may have done something. Number two, the PR firm was hired and they went out and they said the opposite. If John and Patsy said, "Hey, we know it to be this person," and then the PR firm went out and said it was an intruder, and it wasn't, And if the attorneys coordinated and approved the message, um, and then you might have the beginning of this kind of fraud, cover up, deception. Um, Especially if you can kind of go in to show this fraud and deception, I would think through maybe police statements or public statements or statements made through other people, intermediaries, people who might be willing to be a witness for that. Um, I wrote down this note. I don't know if I want to say it. If you have other people, let me say it this way: if you have other people who were either directly or indirectly coached to maintain a narrative that protected the family, and if that coaching came from attorneys, PR staff, or investigators, that chain could, if documented, become central to this kind of crime fraud narrative. Going down further in my notes, we've already gone through accessory to a crime. Obviously, the phrase of another is critical because it means that there's a specific principal actor that you're looking at. That crime must be legally recognized and chargeable. The accessory is aiding that charged person. So if you have, once again, if you have somebody like Burke who cannot be charged due to being under the age of 10, no intruder exists, and no intruder exists, then there is no another under the law. Therefore, charging John and Patsy as an accessory lacks valid predicate under the statute. And so that wouldn't give you probable cause, which might be an issue under Rule 3.8A. So digging a little bit more into this crime fraud exception to attorney-client privilege. The crime fraud exception allows you to pierce privilege when communication was used to commit a crime or fraud or was made in furtherance of a cover-up, obstruction, or deception. This is just in my notes from what I've just trying to do a little research on. This is pretty well established. I think this is like a federal and a state principle that overrides normal confidentiality. So if I find that you committed fraud and you try to commit fraud and use it in the furtherance of a cover up, that is a federal and a state crime. Can't do that. Okay. And so, how do you trigger this? How can we find this? How can we work backwards to find this? Courts require prima facie showing of fraud, meaning sufficient evidence to support a reasonable belief that a crime or fraud occurred. So you need reasonable belief that a crime or fraud occurred, and the communications were in furtherance of that scheme, right? And so this is kind of, I think, one of the best ways to even look at that, to even start to consider that. So first trying to say, okay, is there a reasonable belief? Can we look at the communications that might actually give us insight into that? I don't want to show that part, or I don't want to talk about that part in my notes. But it's just something to the effect of going the way to go about sort of approaching that crime fraud angle that I'm still kind of thinking about. I'm thinking more about that. How you would go about showing that is what I'm working through. Just a different thing, just a few different things. So I'll kind of skip past this point in my notes. But essentially, establishing that is that intentional contradiction, and sort of showing how those contradictions may have shaped public or legal narratives via attorneys, PR, and investigators, and then kind of working backward and saying, okay, based on this information, is there a reasonable is it reasonable to believe that there is fraud somewhere, and so that we can pierce through client attorney privilege in this case. And so that I'll leave it right there because I have some ideas, directions that I want to go. I'll leave it right there. Um, I'm still looking at some stuff. I'm looking at some stuff. Um, about how to approach that. And I'm also looking at knowing that Burke was 10 years old or under 10 years old at the time. How would you approach the case today? And knowing that we cannot use these things, how would you approach the case today? It's kind of what I've been thinking about. I don't know if I want to share that. I don't know. You know, but I'm just kind of considering those things, how you would approach that. What ways? And again, I'm not an attorney, so I don't know. Just some ways that I think would make sense to approach um, approach the case in sort of working backwards to unravel some things and sort of get certain answers and sort of force out certain answers by default in a way. Even though we have that DA Hunter screwed us here, and even though we have Mary Lacey tried to further screw us, in sort of taking these charges off the table, I'm wondering if there's other avenues, because what you can't do, whether you think Burke did it or not, if you're BDI, you can't charge him. That's dead in the water. It's done. You can't charge him. So, I mean, it is what it is. That's just the law. At being 9 years old at the time and being under 10, you can't say, oh, now that he's, it can't happen. And so somebody being charged for the murder of JonBenet is completely off the table. In Burke's case. And what's weird though is the way they presented the case and came up with the indictments. Commander Eller, or I'm sorry, Chief Beckner should not have been disheartened. If the intruder theory was true, then this is only the beginning. We have plenty more people to look at. But I'm suspecting that Chief Beckner may have been disheartened because they were of the strong belief in what they were expecting to be presented was that this was internal, and that's no shock. That's no surprise. But what I'm saying is that the way in which the charges were framed and put forth, he's saying may have tied our hands behind our back. And that is frustrating because he's saying, hey, you tied our hands behind our back and we can't, and that severely limits our ability to use certain avenues or angles. I don't know. I don't know if I'm ever going to present that in my perspective. I'm not sure. So, yeah, that's everything. I think next time I have some information on Patsy that I want to talk through, or some stuff on Patsy that I want to talk through and just kind of get a better idea on that. And yeah, appreciate all your support and whatnot. And hope you're relaxing and taking it easy. And thank you for liking, sharing, and subscribing. Thank you for watching. And until next time, take it easy.